In this episode, we're going to be delving into the legal side of buying your first home. What's in a contract? What's not in a contract? And what questions should you be asking your lawyer or conveyancer? Welcome to Your First Home Buyer Guide, the podcast for first home buyers who want to get it right.
I'm Megan and that was Veronica. We're both buyer's agents and probably old enough to be your mums. But that's a good thing because between us, we've got over 40 years experience and we are going to share with you bucket loads of stories about avoidable mistakes. Together, we're going to make sure that you get unbiased and real information that you can rely on so you can get where you want to be without missing a step.
Now, we've got loads of great tips for you in this episode, and if you'd like more useful tools, head over to the website homebuyeracademy.com.au. There you'll find free checklists that you can download, a free mini course on how to price a property, and our Where to Buy workshop for only $39. Priceless stuff, really.
Bargain. But before we get into the interesting stuff in this week's episode, here's the boring bit, the disclaimer. You, of course, know that nothing in this podcast is to be taken as personal advice. We always recommend getting the advice of an expert in their field of expertise. Now, we've done our very best to ensure that the content is correct at the time of recording, but things change. So check with the relevant government authority or your advisors to get the most up-to-date information.
Now, we've got a new workshop that we're bringing to you. It's the Stepping Stone Strategy Workshop. We're running this online live, on Saturday, 19th of June from 2 o'clock in the afternoon. And you get to do the workshop, but also ask us loads of questions.
Looking forward to it. I'm quite excited about this one actually because we ran a poll and we asked people, what do you want from us next? What part of our brain do you want to pick? And it was rent bursting versus stepping stone strategy, and more than double the amount of people wanted the stepping stone strategy. So if you want to make sure that your first property does the heavy lifting to make sure that your dream home will be achievable in the future, then the Stepping Stone Strategy Workshop is the place to come to get the foundation steps right so that you get that first purchase on the ladder right and then can step towards the dream home.
Now, to find out more, look at homebuyeracademy.com.au/SSW. It's that simple, but we will put the link in the show notes. These live workshops, we only do them a few times a year and they're fantastic, so please join us. Today we have an expert guest to help us navigate the complex legal side of buying a property. Jenny Tonner is joining us and she brings along literally decades of conveyancing experience. Thanks, Jenny. Nice to see you.
Welcome, Jenny.
Nice to see you both and thank you for having me.
For some people, they'll be listening to the podcast. They won't be seeing us, but that's okay.
Yeah.
Jenny's looking great. Jenny, can we kick off with an explanation as to why a buyer needs to get legal advice and when they should do that?
Yes. So you need to get legal advice because when you buy a property, you're actually entering into a legal contract, a legally binding contract with the owner. And that contract contains various obligations and warranties in it that a purchaser must comply with or state is true and correct. So you need to understand what those obligations are and what it means if you cannot make those obligations or conditions under the terms of those contracts. Most obvious being if you can't make the settlement date, if you can't complete. So that's why you need someone to look at that contract, explain those terms, so that you are fully aware of what you're entering into and what those obligations are before you pay a deposit and commit to purchase.
There's also obligations on the seller's behalf that are outlined in that contract too, aren't they? And things the seller does and doesn't have to do that the buyer should be aware of?
Yeah, so under every contract, a vendor has what are called prescribed documents and prescribed warranties by legislation that governs that contract.
Now we're talking about New South Wales. I'll just point out we're talking about New South Wales here, vastly different in different states.
Vastly different,
in New South Wales,
So a vendor must disclose certain documents by attaching them to the contract, title searches, planning certificates, sewer diagrams, And if you've got, if you've done renovations, you should be attaching compliance certificates, evidence of consent. If you're acting on the sale of a strata, you should be disclosing whether you're aware of special levies, anything that may impact the value, occupational use of the property. That a vendor is specifically aware of, they must disclose those under those prescribed warranties. And then outside of that, a purchaser needs to test that by asking relevant questions to the vendor before you enter into a contract, and then during exchange and completion through the requisitions on title.
So this is an interesting, very, very meaty topic. Okay, now we do go into this in your first home buyer guide because we need, first home buyer, every buyer needs to understand the obligations that they're entering into, but also what has to be disclosed by the vendor and what isn't disclosed by the vendor or doesn't have to be disclosed, and what you have to find out yourself. And so this is very different in different states. Now, Jenny, I know that in a previous job that you've had, or a previous role before you set up your own business, you worked across other jurisdictions, so not just in New South Wales, but now you're obviously licensed in New South Wales. Can you give us sort of some examples of what is different in other states? Because I know that in New South Wales, the vendor disclosure is higher, or the level that they have to disclose is higher than pretty much anywhere else. But I don't believe it's even enough. I actually think it should be more, but that's a totally different issue. What's the difference between New South Wales and other states?
Well, it comes down to the state legislation, because in New South Wales, they say that certain things have to be disclosed through documentation or warranties, but it doesn't cover everything. It doesn't cover the state and condition and repair of the property. You've got to go do that yourself, which I'm sure we'll get onto. But other states like Queensland basically put the onus all on the purchaser to go and do that themselves. We are not disclosing, we are not warranting anything, you do it. The same, I think, in WA. It's been over 10 years since I've done something in WA, so I don't know if there's changes there. In South Australia and Victoria, they have things called vendor disclosure statements. Again, they are required under those statements to disclose things, but they're also limited. They do require the purchaser to do their own form of checking and due diligence in relation to some things with the properties, and ask those questions through their solicitor conveyancer before entering into the contract. And that's why you need that advice there, because we know what the contract should say, what it's not saying, what we should be asking.
That's such a good thing.
Such a good point.
Yeah.
Because you don't know what to ask, do you?
That's it.
And then you really need that guidance of a solicitor asking really good questions, because of course the conveyancer or solicitor hasn't seen the property. So the buyer has to know, give some hints to the conveyancer to say, well, it's a renovated house. Oh, okay. Well, we need to seek some documentation that shows that it has the appropriate certification. So as a buyer, there's a real, you really need to know the right questions to ask of the conveyancer to make sure you get the right searches back, because you're not mind readers either, are you?
No, and I don't see the property. So where I can, as part of my review, I will always go look for the agent's advertisement, because that gives me an indication of whether, what you said, renovations have been done. So where an advertisement and where an agent will highlight, isn't this fantastic? This has got a studio and a cottage out the back. And isn't this fantastic? You could use this as your home office or Airbnb or blah, blah, blah. In my head, I'm going, have they got council consent for that? Or did they just pop that up over the weekend, put some drainage in? Because if council become aware of that and it hasn't been complied and consented to, there's a notice on your property saying pull it down or go get the consent. They're the kind of things. Strata, it's the same with the strata unit. If I can see a picture of the strata units and clearly see that new floorboards have been put down,
we were just talking about this, weren't we?
I need to know that there's an owner's consent for that, there's a bylaw for that, they've complied with the insulation requirements, so that if you move in, you're not going to, excuse the language, but piss all your neighbours off because you went
with your high heels on the
and you had no idea that the previous owner left because they angered all their neighbours because they didn't comply with their requirements under the bylaws.
It's
Like
such
I've dealt
a
with this
big
before.
one in apartment complexes, isn't it? Because people are more and more moving away from carpet, and carpet, has that insulation property to it and muffles a lot of the noise. So as people are renovating and upgrading their apartments, it's such an important question to ask of the seller and the conveyancer to actually do the right searches on that.
Yeah.
So this is interesting for so many reasons, but one of them is that, okay, I want you to explain the difference between lawyers and conveyancers in a moment. But the thing is with lawyers, a lot of people think, you got to use a lawyer because, they've got a law degree as opposed to what a conveyancer has. And you're going to explain that. But not all lawyers know anything about property.
Oh my God, Veronica, you and I have done this together. Yes. So, okay. We don't have a full degree. We have a partial degree, and that's specific to property. So we can't act in litigation. We can't go to court. We can't give tax advice, that type of thing. Our qualifications and our license allows us to act purely in relation to conveyancing.
So it's very specialised.
So it's very specialised. It's like you go to a general practitioner to talk to them about an ailment, and that they'll have a broad range of, like a GP, have a broad range of knowledge on all subjects, but they're not a specialist in a particular area. They'll refer you off to specialists. Not discounting law degrees, absolutely worth, having, and certainly great lawyers out there. I'm not saying it. I worked 20 years in the 2 largest law firms in the country, and all of my experience and knowledge has come from the mentoring I got from there. But saying that, conveyancing, we still have exactly the same professional indemnity insurance requirements as a lawyer does. We still have the same professional compliance standards. We have the same education requirements, continuing education requirements each year. And we have the same auditing and compliance requirements on our trust accounts as a lawyer does. So everything in relation to the practice and running a business and running a conveyancing business is exactly the same. We take the same risk as a lawyer does. We just are specialists. That's all we can do. Yeah.
Okay. I want to delve a little bit more into that because there's a proliferation of cut price conveyancing firms offering very discounted rates for and actively advertising very discounted rates. Now, I really want us to differentiate between a professional conveyancing firm and a cut price conveyancing firm. Jenny, you're certainly not a cut price conveyancing firm. You've professionally worked with Veronica for a long time. Tell me, what are some of the things that you've seen that people have got into trouble or challenges people have faced if they've gone for the cheapest option and something comes up in the process?
Well, I've had a lot of experience with these firms because they're acting on the other side of transactions that I'm on.
Mm-hmm. Okay.
Yes.
Right. Yeah,
good. Or I've ended up with a client afterwards saying we did that and we've regretted it. The main is that they're just not contactable. They're not contactable, and a lot of it is robotic responses because that's how they keep the price down. They also they can't do it so much now. We've gone electronic with our settlements, but in the older days where we had paper, they would push all the fees onto the other side. So if they didn't serve this within a date, if they didn't do this within a date, and they were charging in some of these contracts up to $3,000 more onto the other person on the transaction for doing their work. So, but now what I see commonly on the other side of a transaction, we can't contact them. We can't chase them. They don't deliver things when they're meant to. They don't perform and put documents in the workspace. They don't chase their banks, and they fail to meet completion dates a lot. What that means to a purchaser where they act for that is that exposes them to the default interest in the contract. And then that puts them at risk of losing their deposit. So I understand that people are looking to save money when they're buying property when they can. But Veronica and I've talked about this before. It's so important to get the right advice and have someone who's acting on your behalf and that is looking out for you and doing it. all conveyancers have fixed fees, but what we as an industry see, and I'm on the board of New South Wales Institute now, is we're seeing this cut price, and what we're seeing time and time again is they don't have the level of experience they should have. Yep. And they don't understand the law, and they don't understand the impact to their client by not knowing the law.
There's a care factor there too, Jenny, I want to touch on too, because you said it yourself. You'll have a look at the ad. When a purchaser comes to you with a contract, you'll have a look at the ad. It sparks a line of questioning that only a human can really undertake, and it's an experience and an interpretation and oh, it's got this, we need to think about this. If you've sent a contract off to a firm that is largely robotic, there is not that care factor is not going to be there, is it? There's no investigation going to be done. You'll be sent a list of searches and asked which searches you want the conveyancer to undertake, and you then have to know which ones. How would you know when you've never done this before?
But isn't the point is this is your biggest financial commitment to date as a first-time buyer? Don't you want the person who's helping you do that feel confident that they are on your side and looking after you and know what to ask and what to order? And I've had clients come to me saying, we didn't even have the contract explained to us. And that's terrifying, because I can't even sign a 66W certificate waiving a cooling off period without me saying I've explained the contract to someone. So that's telling me they're automatically in breach of that section of the law because they haven't done that.
Yes, I have come across. We've spoken about this before, about in New South Wales, you need a 66W certificate if you want to waive the cooling off period. And you might think, why as a buyer would I waive my cooling off period? Well, if you're going to go to auction, you buy without a cooling off period. And if you're buying in a hot market, or you're trying to buy a property prior to auction, you're going to have to waive that cooling off period because it's competitive and another buyer will. So in order to do that, you have to go and get your contract reviewed by a lawyer or a conveyancer, and they will issue that certificate. Now,
again, that's New South Wales, not other states.
That is just New South Wales. And now I'm constantly amazed that in Queensland you can actually waive your own cooling off period without actually understand.
You just sign a form.
Without having requested
we don't recommend
one document. It's nuts. We
don't recommend this at all. So it is state by state differences. In Queensland, you can just sign a document waiving the cooling off period without getting any legal advice. Do not do this.
No. Now, Jenny, I remember the first time that I met you, we actually interviewed you on the Elephant in the Room podcast, and you talked about all the sorts of things that, people completely unaware of, and in particularly I remember the fear that sort of ice ran through my veins when you talked about contracts put together by developers for brand new property. And if you want to give us a bit of a rundown of why they might be a bit different to say the contract may be drawn up by, Ma and Pa down the road when they're selling their unit. What is the difference and what do first home buyers need to be aware of, apart from the obvious risks associated with buying brand new and buying off the plan, but what's the difference in a contract for buying that?
Well, it's the difference between a conditional contract and an unconditional contract, and what you're buying is built and what you can see what you're buying, as opposed to something that is on a plan and is being promised to be built to you. So you're entering into a contract on the promise that a vendor will be building and will deliver a unit based on something you've been shown in a showroom in an agent's office. And it will be fitted out with various schedule of fixtures and fittings. And on completion, you will buy this unit, and it will be what it is. Now, there are a lot of provisos in an off-the-plan contract that aren't in a normal contract. One is a sunset date. You have to have, when you've got a conditional contract that's subject to things being built and things being delivered, you have to have a sunset date. You can't have a never-ending completion. You have to have a date in which, if something hasn't happened by that date, either party can rescind and walk away, or you have a right to extend. And that's so that it doesn't go on forever. because you're sitting there, you're committed under a legally binding contract, which you can't get out of. You've paid a deposit that's sitting there in a trust account of an agent or a vendor solicitor, and it's there. And until that sunset date is reached, you have no rights to try and get it back. Now, what we're seeing less and less of it now.
Who's that protecting, Jenny?
It's protecting both parties. It's basically saying they're legally committed to complete the contract, but it's not released to the vendor until settlement.
I actually remember a period of time where we were having rapid price growth and developers were frustrating contracts in order to invoke the sunset clause.
Yeah.
So they were not doing the development. They were invoking the sunset clause, reselling at higher prices because they realised that, the market had moved in such an upward direction that they could get more money. So that's right. And as a buyer, that there was nothing that those buyers in those contracts could do except pay the higher price.
But they can't do that in New South Wales now because I think it was when Mike Baird was still in government. He brought that in where they can't do that. They basically can't delay completion to get to that sunset date and exercise that right. They have to show, they have to be committed. And that's exactly what was happening. People were buying, but they were entering into these contracts with 4 to 5 year sunset dates. And the capital gain in that period was so high at that time that buyers were benefiting the capital gain by on-selling. And we can talk about on-selling in a minute because that's a whole other can of worms.
Yes.
But I think that's a whole podcast topic.
That's a whole podcast. But you'll have some contracts will have sunset dates of 3 years. That's telling me they've at least got development consent and they'll be breaking ground. If they've got sunset dates of 4 to 5 years, that's telling me they haven't got development consent yet, maybe not even financing to build.
What a piece of gold. And that only comes from experience, that one.
But so I personally will say to my clients, can you think about this? Because I've had clients in this situation. One was he got transferred overseas halfway through the development. So by the time it came to settle, because he was living overseas, his lending capacity had dramatically reduced and he couldn't complete. And we had to rush around and get the sale done. And another fellow, he bought it as a single young man, put down $80,000. 4 years later, they still hadn't broken ground because they still hadn't got the consent that they wanted. And he had met his partner by that stage and they wanted to buy something and he just wanted, his life had changed. His circumstances had changed.
It's a long, long runway, isn't it, 4 or 5 years?
So I was very lucky with him because that contract was so appalling that I just went hammer and tong and got him out of it and got his deposit. And then they went and bought a place together, an existing one, not an off-the-plan one.
An established property. Because this is the thing too, that if the market, you're taking a risk when you're buying something. It's like you're buying futures, right? I'm betting that whatever I pay today is going to be less than what it's worth tomorrow, but that's not necessarily the case. And then in cases where it is worth less than what it's worth tomorrow, in 4 years' time, prices have gone up. How much more could they have gone up if I actually went and bought a more appropriate property for myself that was brand new and I could have been living in it the whole time? So it wasn't brand new, I should say, and I could have been living in it the whole time. So there's massive missed opportunity just as life.
Big opportunity costs.
Yeah, as life gets in the way, basically.
Yeah,
of course, I think it can go the other way too. Let's not forget that you can lose money between the date of the contract and the price you paid and when that property settles. It can go backwards. It just doesn't always go up.
And I think sometimes first-time buyers can get caught up in what benefits do I get from the government because I'm buying off the plan. And you've got to weigh that up in terms of the reality of the build and that period of growth. Like, yes, you might not get stamp duty exemption, but what does that mean long term when you weigh up what the cost could be to you in 5 years' time?
Like we're just all reading from the same hymn book, aren't we?
But, there's a whole podcast just on off the plan. We talk defects and defects periods because every new build will have defects and what your rights are there, the quality of inclusion. So your schedule of finishes should have brand names in terms of the brand of the appliances. because there's a clause in every contract that says they might not be able to source that brand, so they must replace it with, I will say, quality, the same quality and value, so that if they're advertising, you know, the place fitted out with Smeg, say, you want that to be replaced with something equivalent to Smeg, not something from, you know, Bunnings or whatever.
We won't bang on too much about Bunnings. Yeah, exactly. Yeah. We won't bang on too much about this because we don't necessarily recommend in the course that people buy off plan, but we want to raise people's awareness, and that's the really important thing. If a developer hands you or an agent hands you a contract, that has to be looked at by your legal advisor and appropriate changes suggested. Now, it's up to the other side as to whether they agree to the changes. Yeah.
The most important thing with that, Megan, is that they will be trying to commit them to enter into a contract in the display room with a cooling off period. That's all part of the deal, right? And then
special deal for you right now.
Right now, if you commit to this, and you'll have a 10-day cooling off period to get your deposit organised and get your contract looked at by your conveyancer. Guess what? Like, yep, I have the ability in those 10 days to look at a contract and ask for changes. They have no legal obligation to agree to any of it. So always get your conveyancer to look at it before you sign a contract. That's so important. If that's the only one thing you take away from me today, please do that.
Of course, with the cooling off period, there's a penalty if you withdraw under the cooling off period as well. So it's not, it's much, much more important to have the advice before you sign the contract than after, because it could end up costing you money if you've got to get out of that contract under cooling off.
And that's not just for brand new properties. That's for any property you're buying with a cooling off period. And I have to say, when I first met you, Jenny, I actually didn't know that because we buy very little with the cooling off. And I'd even said to people, oh, you know, you can get your contracts, you know, reviewed and contract changes in the period, in that period of time. It's what I was taught in the real estate office that I sold in. As I said, I very, very, very rarely sold anything with a cooling off period, but that's what we told people. And agents, it's a bit like the agents that say, oh, great investment when they're selling a property. Agents say stuff that they don't know. They all the time, they say things that they don't know.
The job's to sell the property.
Yes, exactly right.
Your conveyancer can sort that out in the cooling off period. Sort that out for you.
It's easy. No problems. So, and I think that that's a really good point, because there are times on a Saturday afternoon when agents are signing up contracts in their office. You know, no lawyer's seen it. Their buyers, they're sitting there going, okay, well, I've got five-day cooling off period, which is standard in New South Wales and
Queensland.
You know, I've got till 5 p.m. on next Friday to get everything sorted, all good. And you know, most of the time it probably will be fine, but there will be times when it won't be, and you don't want to get caught out. And it's just worthwhile waiting till Monday and getting your contract reviewed by your solicitor or conveyancer. What does happen? What, other than the fact you can't necessarily change the contract in a cooling off period, what else happens when you sign a contract with a cooling off period?
So with the cooling off period and under the cooling off provisions, you put down 0.25% of the purchase price. And what that effectively does, and why this legislation came in, was because so many people were being gazumped. They had an offer and acceptance with a vendor. They'd go and often start getting their pest and building report, finalising their finance, and then the vendor would go and gazump them. And so it allows a purchaser to put down a bit of money, not the full deposit, go complete their due diligence, and it takes the property out of the market for 5 business days, so the vendor cannot sell to someone else. And then by the end of the 5 days, if everything, all the boxes are ticked, you pay the balance of the 10% deposit and the contract goes unconditional. If you can't proceed or you don't want to proceed for any reason, you have the right to rescind, but the vendor is entitled to that 0.25% because you've taken their property out of the market for 5 days. So an agent can still show the property in that 5 days, but they must advise anyone going and looking at the property that it's under a cool-off. So they can't take any offers. But they certainly can't negotiate to sell to anyone during that period.
Now, gazumping's an interesting thing, isn't it? So gazumping is where you've had your offer accepted and a deal struck, and then someone else comes in with a higher one and the agent / vendor sells the property to them and not to you. Now, there's ways, in various states to avoid that, and you can sign a contract very easily in Queensland, for instance, a conditional contract, and avoid that. But as you said, Jenny, the legislation in New South Wales is that the cooling off period was provided for that reason. But gazumping isn't illegal, is it? Really? No. I mean, a lot of people think it's wrong, it shouldn't happen, but it's actually not illegal. And so really the only way to make sure that you don't get gazumped is to actually enter into a binding agreement, correct?
That's right. Yeah, that's right. And that's the whole reason why the cooling off legislation was created. I'm showing my age here now, but I started when there was no cool off, and it was happening all the time. To people, and it brought it in as a relief for purchasers to try and go and get their due diligence, get their finance approval, get their pest and building reports or strata reports without fear of spending all that money and time and then losing out because someone's offered them, the vendor, $5,000 more. So that was the whole point of it. And you use that 5-day period to go get your pest and building, to get your finance, because you can't make a contract in New South Wales subject to finance approval. You can't do it in New South Wales. The laws won't let you do it. I know you can in Queensland, but you can't do it. The Consumer Credit Code legislation doesn't allow you to do that in New South Wales. So you can only exercise the cooling off provisions to do that.
Oh, how interesting. Yeah. Okay. So there's a lot more seller disclosure, but a little bit less protection. Well, not protection, but you have to actually be in a binding contract with and use the cooling off period in order to get that final finance approval valuation done and so forth. Different in Queensland, where you can make an offer that is subject to building and pest inspection, subject to finance, subject to body corporate record search. And these are all because there is so much less seller disclosure in Queensland and the onus that, KVM to let the buyer beware. So the buyer has a lot more onus on themselves to do the right levels of investigations to satisfy themselves as to the pros and cons of the property. And you can't be gazumped in that time because it is a binding contract.
Yeah, and that's right, but we don't have that in New South Wales. So you can only exercise the cooling off provisions to give you that ability to go enter into a contract, get a property off the market and go complete your due diligence. And the reality is in Sydney, the demand is so high in Sydney that cooling off's very rarely offered.
Yeah, right.
Because no vendor is going to take their property out of the market for one buyer when they've got 6 other buyers wanting to buy it.
That's exactly right.
Good observation of the market at the moment. And of course, we're in end of February 2021, which is absolutely, if you're listening to this at a different point in time, the market might be different, and there might be different opportunities to make conditional offer or subject to cooling off. Yeah,
February, March 2020, we were seeing cooling off provisions being offered.
Right. You see more of those on the contracts. And then people got their heads over that, and Veronica will tell you the market went gangbusters again. But definitely, depending what's happening in the market and what's happening overall, yes, it will happen occasionally. Outside of Sydney, you'll get offered it more and more.
Absolutely. And then look, I know I've been now in it 21 years, and there's been periods of time, slow periods where you can buy with a cooling off period, and then it's like, forget it. So it's very much such a good point that it is all about market conditions. And yes, look, Jenny, what are some of have you got any little stories for us on mistakes that first home buyers make that you see a lot?
I did actually. So I think that they get very influenced by what an agent will tell them. I think the most important thing for buyers at the moment to understand is that they should not be entertaining exchanging a contract or buying a property unless they've got pre-approval with a bank. They've got to have pre-approval with the bank to be able to put themselves in a position, because you can't make that contract subject to finance. And we're just seeing in the last 12 months, the turnaround times with the banks, the lenders, has slowed significantly, and there's a lot more boxes to tick with your lending. You need to do that first before you contact me to engage on the legal fight and say, I found a property.
Yeah. We always say don't start shopping until you've got your money in order.
Yeah, that's very important. And then just understanding what the contract is asking of you. You know, things like when I do a review, I look at things like renovations and that, but I also look at the list of inclusions, because 90% of the time, the list of inclusions is missing something. Right. And and people will go to do their final inspection and go, oh, the dishwasher's gone because the vendor wanted to take the dishwasher, or they've taken all the light fittings, or they've taken all the TVs and TV brackets off the walls and have left big gaping holes in the walls. You know, just things like I did a commercial purchase once where the stairs to the mezzanine level was taken by the tenant because the tenant's the one that built it. And so we go to do a final inspection and there's no access up, you know, and the
just a hole in the ceiling.
Hello, because anyhow. I'm a bit anal about that. But another one is agent warranty. So you as a purchaser warrant under a contract that you've only been introduced to the property by the agent on the first page. So let's talk about a listing where a property's taken a while to sell.
Oh, this is a good one.
It may have been listed originally with, say, LJ Hooker, and then their agency agreement was terminated, and then 6 months later, and you looked at it back at LJ Hooker days, but you thought it was out of your price range, you didn't have your finance approved, and you weren't ready to buy. And then it pops up again with Bell Property, and you're in a better position, and you go this time to Bell Property. That warranty catches you because Bell Property is named on the contract as the vendor's agent, but in fact, LJ Hooker introduced you originally to that property. So you're in fact liable, and you're warranting in your contract that you'll protect the vendor from LJ Hooker claiming a commission.
Wow.
This is why you need someone who knows what they're doing. It's a big one.
Yeah.
Because you want
what that means is you could actually have to pay the commission.
No, hang on.
LJ Hooker's commission.
Yeah.
Yeah, potentially, yes. But the thing is, I've seen this happen, and I will give you a story on this. I've heard, though, that if LJ Hooker can't demonstrate that they actually actively worked with you as a buyer, as opposed to you just coming through the door and they take your name and number, that it doesn't really count. I've heard that, whether I'm rightly or wrongly, you're pulling a face. So I'm presuming that I may be wrong.
Yeah, no, that's right. But an agent's required to list who they've introduced to the property.
Yes.
So if I was acting for that vendor and I terminated that agreement, I'd be getting a copy of that list when I terminate that agreement. And I'll be, so that if the eventual buyer's on that list, before the vendor even commits to a contract, you want Bell and LJ Hooker agreeing on a commission split.
Very good point. And
wow. Yeah. That just blew my mind.
Because the purchaser, I would be saying, if I'm acting for the purchaser, I can't give that warranty.
This is very New South Wales centric. Let's just point out it's definitely not.
Yeah, I mean, in New South Wales, you do have a whole section of special conditions in every contract, and that's usually in the special conditions, right? Mm-hmm. That warranty, and some may not have it, right? But I've had a lot of our clients sort of say, "Oh, but you introduced us to that property, so that's all right because you're paying us, and we won't be charging the vendor. We're not the vendor's agent." But I did go. This is just a story about an auction some years back. So this is a woman who she was a widow, which is very sad, and she had this property to sell in Leichhardt, and she came to me, and it was a beautiful looking home, but inside the floor plan was really bad. Like it needed a lot of work to make the inside as good as the outside, put it this way. And she wanted a crazy amount of money for it. And I said to her, look, until the market wasn't very strong at the time, I said, until you're ready to meet the market, don't put your house on the market because the money you want, I don't think that it's going to get in the current market. So don't list it. So she was a friend of a friend, right? So she was getting a little bit of free advice that she chose to ignore. She goes out there. She goes and lists the property with an agent. and goes through the whole auction campaign, the whole bit, pulls it just before the auction because they don't have interest at the level that she wanted. She's not willing to meet the market. So, and she wanted like $2 million from memory, right? And there was a buyer there prepared to pay 1.7 something. And I knew the agent very well. And he said to me, I've got this buyer. She wants this property. She'll pay more than everybody else, will for this property. But the vendor is so out of control with price that it can't meet the market. So we're going to withdraw the market and withdraw the listing and hand the keys back. So basically they resigned from looking after her. About a year later, the market's starting to look a bit better, but it's not massively different. She decides to list with another agent. And this is an out-of-area agent, sort of an old school friend of hers, not from that area. They go to auction. At the auction, and I go along just to watch, and there's the original agent there bidding on behalf of this same buyer that a year earlier had wanted the property. And here he's there acting and bidding on her behalf. It passed. By this time, she really needed to sell it. And so passed in, they went inside, they negotiated the whole palaver. That ends up she pays less than she would have paid a year earlier. So she's paid in the 1.6s, hasn't even got to 1.7. She's the only person there at that level. So they're forced to negotiate with her. She pays less. The next minute, and there was no clause in the contract warranting her. Next minute, the vendor gets slapped with a commission from the original agent. So the vendor actually got copped for both commissions, sold it to the same buyer for less money, like whammy, whammy, whammy. So,
and
this is not...
That agent also charged the purchaser a fee for helping her buy the place.
Probably. Actually, I don't think he did, but he didn't need to.
No, shouldn't have.
But you know what they do, what they can do.
Anyway. This is obviously not a first home buyer story, but it does show how complicated the whole legal aspect of things, getting good advice and taking good advice. I mean, you should have taken my advice, but she wouldn't have listed then, put it that way. She would have only had one agent because she wouldn't have listed it in the first place. But the point being, she obviously, I don't know if she used the same lawyer both times. I don't know what the story was, but she didn't have the right people on her team giving her the right advice. And the principle is exactly the same.
Left it very exposed.
Absolutely. Anyway, war stories. So that's...
and it's the same with pest and building. A lot of buyers don't want to get pre-purchase inspection reports. But one thing they don't understand is the contract very clearly states you buy the property in the condition and its state of repair as at the date you enter into the contract, not the date of completion. So where you're wanting to save money by not buying pest and building reports or strata records, you're taking the risk of not knowing as at the date of the contract what is going on with that property. So for a strata, the most obvious thing is that there's a special levy about to be hit, because as soon as you enter into that contract, if that special levy was raised the next day, you're liable for it. And I've had buyers do this where they've missed out a couple of times. The agents ended up selling my client a unit in the same block that she had missed out on. She decided not to get a strata inspection report. She just wanted it done. She didn't want to have to go to any more opens. She got hit with a $60,000 special levy a month after completion because the reports weren't checked. Okay, and we would have, if we'd been given the time, we would have negotiated that. And it's the same with pest and building. You don't know, particularly with older homes, you don't know what's happening with under the subfloors. You don't know if there's a leak
in the ceiling voids.
Yeah, you don't know if they've put the dodgy insulation backs up there. You've got to know what to ask and ask them before you enter into it and understand that position.
I think that's the theme of this episode, is knowing the right questions to ask. And in order to know the right questions, you have to get the right advisors, the right expert help. And there's no point getting a lawyer that doesn't specialise in property. In New South Wales, they're called a accredited property specialist, right? Is that what they're called? Jenny? A lawyer? It's an accredited property specialist. I presume in every other state you have something similar. And obviously with conveyancers, avoid those cut price ones like your life depends upon it. And look
because
to someone.
It does.
Yes, quite close, actually, yeah. And look for someone who absolutely specialises and takes the time to do the extra things like Jenny does. Look at the link. It's a really little thing.
I pick one, but most don't. Most
absolutely
don't. And then what are the right questions for them to ask you if they don't at least eyeball the property online?
And if I can't see it online, I will say it in my review to my client. I have not been able to see this property through any advertisement. So I'm relying on you to tell me what are the inclusions? Have there been renovations? Have there been changes structurally to the unit? So that I can then ask those questions up to the other side. And don't forget that if I ask that question, say is there a special levy? Is there a current special levy or a likely special levy coming up that my clients are liable for? If the vendor replies no, and then that happens, but we've entered into the contract on the basis that the vendor has said no, you have a claim there because the vendor did know. And so the vendor has dishonestly answered that question. So there are remedies, but you have to ask the question to create that right.
And it's the same when you're signing a conditional contract in Queensland. It's you have to know what things to put that the contract is subject
on the contract.
To. Yeah, if you don't put, it's subject to a building a pest or subject to a flood plan or whatever, you have no recourse.
You have no remedy. Yeah.
Well, there you go.
Some pots of gold in today's podcast. Well, many things to take away.
I'm glad it was pots of gold and not pots of something else. So that's good.
And I love that you've got a potty mouth too there, Jenny.
It's pretty tame, actually.
Fair, it gets way worse.
Yeah.
Woo. Well, thank you so much, Jenny. Really appreciate you spending the time to explain this.
Thanks for joining us, Jenny.
If anyone had been watching our Facebook Lives when we were doing those before we launched the podcast, we did have a almost aborted mission with you, Jenny, where I had you on the phone and I was relaying your answers. Yes.
I know. It was a comedy of technology and people who don't understand it. But but we're here now.
We're here now. Yes. Thank you so much.
Yes.
In this episode, we've covered a very small part of our 10-step online course for first home buyers. If you would like to learn more about the process and how to buy without making a mistake, then head over to our website, www.homebuyeracademy.com.au. Don't forget to subscribe to the podcast so you won't miss an episode. And if you like what you've heard today, please give us an iTunes review. 5 stars would be wonderful. It will help others find us as well.
Thank you for joining us. We hope you found this really useful. And if you have, please share the love with others who you know are in the same boat. We'll be back next week with some more priceless stuff.